you. You can be seated. Thank you. Do you want to call the case, Elena?
Yeah. David March, Joseph Walsh, Thomas Gaffney.
You can be seated. I see all defendants are present on bond. Can the parties please put their names on the record?
Good morning, Your Honor. Patricia Brown Holmes, Special Prosecutor in this matter. Ron Safer, S-A-F-E-R. Kelly Warner, W-A-R-N-E-R. And Brian Watson, W-A-T-S-O-N. And Aaron Gasparka, E-R-I-N-G-A-S-P-A-R-K-A. Assistant Special Prosecutor here in Redmond.
James McKay on behalf of David March, who's present in court.
Judge Todd Pugh and Robert Stanley on behalf of Mr. Walsh.
Okay.
Hey, good morning, Judge. My name is Will Dyke. My last name is spelled F-A-H-Y. I represent Tom Gaffney, who's present here.
Okay, so yesterday we left off in the state's case. Are the parties ready to proceed?
Yes, Your Honor. The first thing that we would ask the court to do is we would move to reconsider the last thing I think that happened last night, the rule of completeness object. We were not clear. I had mismarked the OIG transcript, and I just wanted to try to revisit that with the court. With the court's permission, if I could pass up the transcript that the parties have, the OIG transcript.
Is there any objection to the court receiving that transcript, Mr. McKay?
Not at this moment, no.
Mr. Pugh?
Hey, Your Honor.
Mr. Fahey? Okay, I'll receive it then. And what is it that you're asking the court to reconsider?
So, Your Honor, on page 92, which I have tabbed there, at line 12,
Okay, wait, 1 second. Page 92? Got it.
yes.
Okay.
From line 12 to line 1 was the testimony that Mr. McKay read to Ms. Fontaine, where she is asked, the grand jury, and the answer was the grand jury. I told them what I saw at that point in time, what I remember of the situation. That's what I explained to them at that point in time. At that time, I remember telling March what I saw. And again, after reviewing everything, it kind of differs. Question, and in what way does it differ? Answer, it differs because by looking at his notes, there's where he put that I said he raised his arm as if attacking Van Dyke. I never stated that, or I don't recall stating that to him. And the import, it was used to impeach her about the do not recall statement. That exact subject was revisited at page 173, line 11 to 174, line 4. And this is what we would move under the rule of completeness on Rule 106, or as a prior consistent statement under Rule 613C, where she is asked at page 173, line 11. So the sentence in full reads, quote, McDonald ignored the verbal direction, instead right arm toward Officer Van Dyke as if attacking Van Dyke. Answer, yes. Question, and you're saying you did not make that statement to Detective March on the night of October 12, 2014. Is that correct? Answer, yes. I don't recall telling him that. Question, so when you say you don't recall making that statement to Detective March, is it possible that you made the statement that McDonald raised his right arm towards Officer Van Dyke as if attacking Van Dyke? Answer, no. Question, no, it's not possible. Answer, no.
So what are you asking?
that I would ask that excerpt from page 173, line 11 through 174, line 4 be admitted into evidence either under the rule of completeness, rule 106, or as a prior consistent statement, rule 613C.
Mr. McKay?
I object, Your Honor. While it is kind of Mr. Safer to read into the record those words, last night while a witness was on the stand, Ms. Fontaine, Ms. Holmes did not articulate a question that incorporated that language to the point, Judge, where you stated on the record you didn't understand the question. I objected to the form of the question by articulating that Ms. Holmes was improperly attempting to rehabilitate a witness. Regarding doctrine of completeness, whether Mr. Safer believes that applies or not, it would be nice if the witness was on the stand at the time Mr. Safer is reading these words into the record. His reading is not evidence. And if his partner could not articulate the question clear enough for the court and everybody else to understand, it's too late now.
Any argument, Mr. Pugh?
No, Your Honor.
Mr. Fahey?
No, Your Honor.
Mr. Safer is not saying how I would rule or not rule, but is Ms. Fontaine here today?
She's not, Your Honor, but we could certainly get her here. We could call the OIG. I don't think there's a dispute that those words were said.
It's not a matter
to the
if there's a
OIG.
dispute, but if the court allows that, then I'd have to give the defense an opportunity to recross on that.
Only
If I allow it.
only to the extent, Your Honor,
I know. Only
that it
to,
is, did you say that? The only question that would be asked of her, and was asked of her, it was me, I mismarked the passage of where Mr. McKay started. That's why I wanted to clarify it. That's why we weren't clear about what this was the rule of completeness about. The only question that would be asked of Ms. Fontaine is, were you asked those questions?
Yeah.
Did you give those answers? That's not
I
a
fully understand that, Mr. Safer. I'm trying to determine if it is the rule of completeness or not. I don't have a transcript from yesterday. I did take notes. My notes are usually very good, but because the question yesterday was it was not clear. I'm not exactly sure what was asked or how it was asked, so it's hard for me to say right now if it was or wasn't complete. Are you saying that on page 92 that Mr. McKay only read part of the answer and not all of the answer?
No.
Okay,
What I'm saying
one
is-
second, on page 173, are you saying that Mr. McKay read only part of the answer and not all of the answer, or just not to put the answer in context?
The latter.
The latter?
What I'm saying is Mr. McKay read the portion on pages 92 and 93 that I read in order to impeach Ms. Fontaine. That exact subject was then revisited, and on page 173 and 174, that was read to Ms. Fontaine, but that was objected to. We weren't, I had not marked the predicate, that is what Mr. McKay had used as impeachment, so that we could be clear on the record what it was the rule of completeness for. That's what I'm attempting to do.
Okay, 1 second. Okay, I don't think it falls under a prior consistent statement, but it does fall under the rule of completeness. You're asking me to reopen your redirect. Is that what you're asking?
Yes, Your Honor. I mean, I would hope for a stipulation that those are the words that were said
Well, I can't,
to the elect. Right. I know.
that's between the parties. I can't get involved in that.
Right. So, yes, we'd either ask for leave to call Officer Fontaine for the sole purpose of asking her that one question. Will you ask these questions? Did you give these answers? If there's no stipulation, defendants are under no obligation to stipulate. We have the verdict.
Your motion to reopen is granted over the defense objection.
In light of that, just I will stipulate to what Mr. Staper is asking over my objection.
Thank you, Your Honor. Thank you, Mr.
Okay, so that stipulation is received and admitted.